The Digital Personal Data Protection Act 2023, or DPDP Act, which we'll mostly use, I guess, is India's first comprehensive data privacy legislation. So to help understand the DPDP Act in the context of the needs of RX Pharma marketing, we have two eminent legal counsel and speakers, Vaishali Bhagwat and Aditya Srinivasan.
So I would like to start by saying that 2017 was a very unique and a very defining year for India when it came to establishing the right to privacy. In the modern world, the way we are all interconnected with a lot of data, personal data being shared here, there and everywhere, informational privacy or data privacy is now one of the most important aspects of this bundle of the rights of privacy. Till now, it was the data that was held by large corporations who was gathering data, doing analytics, using it the way they wanted for their business. Also, it was peddled as we are using the data for the benefit of our customers. Now the law is saying, okay, do that, but please be mindful that the data is not owned by the people who are giving you the data. So now there's a total shift in how you understand this landscape of data privacy, data protection, and how one can use.
We're going to look at how RX marketing or pharma marketing interfaces with some of these data protection concepts such as data storage, data sharing, opt-out, withdrawal, the core RX marketing activities, in the sense that these are some of the things that as an industry you will do in order to get to know your doctors better, get to know your healthcare professionals better. And I think the way we should think about the DPDP Act is as a legislation which aims to advance these principles with a view to protect personal data. So the first topic we're going to touch upon is consent. I think the DPDP Act requires that a data principal's consent must be free, specific, informed, unconditional, unambiguous. And it should be an affirmative act. It's not given to a data fiduciary in general. It's given to a data fiduciary with respect to certain personal data, and very importantly, it is given for a certain purpose. Now, there can be multiple purposes for which you take consent, but it's no longer possible, or it will no longer be possible when this law formally comes into force in May 2027 for a fiduciary to infer consent on the basis of one activity and use that or apply that to process personal data with respect to another activity, and which also ties to one of the key principles, transparency. Fiduciary should be aware, and one of the major risks, and I personally believe that one of the main contentious areas in this legislation will be with respect to repurposing of data. I think there'll be a lot of potential conflict and litigations arising with respect to these kind of scenarios where consent has been given for a particular purpose, but it has been used for another purpose. And those are all things which, as fiduciaries, we should all be aware of and be prepared to defend if and when an inquiry is initiated by the Data Protection Board.
Aditya, a quick question on this. A lot of pharma companies have developed HCP databases literally over decades, right?
Sure.
And a key question that is being asked is, what should be the approach taken by the corporate?
I think on this question, Mukul, the law is fairly clear in the sense that the law does some kind of a grandfathering as far as existing personal data is concerned, but it's with some conditions or riders attached. Look, as far as legacy personal data that has been collected by fiduciaries is concerned, what the Act requires you to do is put data principals on notice. They should be made aware of the fact that there are all of these fiduciaries or corporations that have all of this personal data about them, and they should also be made aware of the fact that such personal data is being used for XYZ purposes. So I assume and I imagine that a lot of fiduciaries either are already in the process of or will very quickly initiate the process of building their personal data inventories where they have a clear record of the personal data that is in their possession and the particular purposes for which that personal data is going to be processed. I would recommend that fiduciaries should similarly prepare an inventory with respect to their legacy personal databases. I mean, it's as you say, Mukul, it's highly possible that when consent was taken for this legacy personal data, they may not have broken it down in terms of the various purposes for which that personal data was being used. And I think on that basis, they ought to construct an inventory so that they are in a position. But I think generally as a best practice, it's something that they should do, but also in order to meet their obligation under the Act as soon as it comes into force in May 2027, they should conduct that exercise so they can inform data principles accordingly. We move to the next one. Data collection, and I would link this to the principle of data minimization as well. Pharma companies in RX marketing, what is the kind of personal data that we're collecting? There are the obvious ones like name, contact details, email, phone number. But in addition to that, you're also going to be collecting things like medical specialty, hospital affiliation, and very importantly, prescribing behavior. One of the questions which fiduciaries will be required to ask of themselves, whether it's in RX marketing or any other fiduciary really, is whether every data field is genuinely necessary for the campaign objectives. One of the most important concepts under the Data Protection Act, which is to ensure that personal data is not unnecessarily exposed, are in place to avoid personal data breach. Right? That's one of the core purposes behind this legislation. What that really means is that access should be limited to individuals with a legitimate business need. The DPDP Act requires reasonable security safeguards. If you don't have those safeguards, naturally, and the highest penalty arises in the case of personal data breach, as we'll see, it's in the range of 250 crores. We can move to the next.
I had a question, maybe, is that what are the potential risks if certain legacy data, right, remains inadvertently in the system of the corporate, despite complying with the Act with respect to all the new data generated?
So the law is laying down principles. Means due diligence is something each organization, based on its maturity, its how heavily regulated it is, what level of personal information they have in terms of volume, sensitivity, etc. Now with this, inadvertence also then has to be demonstrated that, see, I did everything that was possible. I had the best. Now the question would now be that how the Data Protection Board will exercise its discretion to believe you. So full discharge and full due diligence if I say in letter and spirit is required.
The point I really want to highlight over here is that sharing of personal data itself cannot share personal data without consent. And if you are going to share personal data, and the data principal should be aware of who will receive the data, why it is being shared, and how it will be used. You can call it one of the brilliant features of this legislation is if a data processor to whom a fiduciary has transferred personal data for the purposes of processing commits a mistake which results in a breach, it is the data fiduciary who is on the hook.
Now, does this also mean, of course, there is the agreements that you may enter into, the terms between the pharma company as a data fiduciary and any third party as a data processor? Will this also imply that there might be need for example, insurance at both ends to address some of these challenges, potential challenges?
I think so, and I know that already that a lot of people are talking about personal data breach insurance. The market has actually come into existence for personal data breach insurance, specifically for DPDP breach insurance. That would be one of the ways in which you can allocate risk, between contractual parties. So that's a good point, Mukul. Thanks for bringing that up. I just want to flag one more thing, I suppose, over here. There'll be a few edge cases where a data processor is doing a little bit more than what the data fiduciary is giving, contracting the data processor for. And those are the kind of situations where everyone has to be very, very careful, because in those circumstances where the processor is going to essentially determine the purposes and means of processing of personal data, they become a data fiduciary itself. So just I suppose the takeaway over here is just be very careful about how risk is allocated between contracting parties. Again, this is This is very closely related to consent, all of consent. The very simple premise of the legislation is that if a data principal withdraws their consent to processing of personal data, their fiduciary needs to stop the processing of personal data. And if there are processors involved, ensure that the processors also stop the processing of personal data. The Act is very clear that the withdrawal mechanism should be as easy as it is for a data principal to give consent. So ensure that the withdrawal mechanism is simple and effective. Very quickly, consent may have been given for, say, 3 or 4 purposes, and personal data might be processed for 3 or 4 purposes. But if consent is withdrawn for only one thing, for example, if a healthcare professional says that I no longer want to receive emails from you, then you need to stop processing personal data for that. But you may still be able to process personal data for certain other, the other purposes.
So one question here by pharma companies reaching out, meetings through their field force of MRs, right? If suppose a HCP goes ahead and says, look, don't send me any marketing materials digitally, etc., then does that in any way impact the ability of the field force itself to go ahead and still meet with the doctor, send some material to the doctor because you think that's what is relevant or useful, maybe following a discussion with that doctor? So how does this all play out from the perspective of the DPDP Act?
Says the following are the exceptions. One is data which is not in the electronic or the digital form. The DPDP Act does not apply to it. You can opt out only for 1 or 2 and then the rest remains.
Again, the Act says that you need to stop processing and retaining personal data once the purpose is fulfilled. Again, one of the questions which you may be asking yourselves is there a defined and enforced data deletion policy? I think it's a good practice for fiduciaries to implement, defined retention schedules, have periodic database reviews. If it's feasible, consider automated deletion mechanisms. Without a defined policy, it's extremely likely, I would say, that your databases will end up accumulating tons and tons of outdated personal data. And eventually, the more personal data you have, it's very simple, like the larger your compliance risk. If we move to the next slide, we can look at some of the questions. So are we tracking content views, engagement time, or webinar participation? Here, look, if any of these insights, any of this information can be linked to an identifiable individual, then it would definitely constitute the processing of personal data. The way personal data has been defined in the legislation is if it is able to identify an individual, or if that information is capable of identifying an individual, then it becomes personal data. That's a very simple and straightforward definition. And I understand that it's extremely expansive, then please be aware that the rigors of the legislation will apply to you. Have users been informed that their engagement behavior is monitored? Look, not only do they need to be informed about that, but if you are monitoring their engagement behavior, then the data principal's consent definitely needs to be taken. If you do not adequately disclose the fact that you're tracking behavior or that you're monitoring behavior, then you would risk falling foul of the transparency principle that we looked at the very beginning. I think one key thing to note is that the Act doesn't really talk about different categories of personal data. So there were earlier versions of a data protection legislation which had things like sensitive personal data or critical personal data and things like that. Here the Act is very clear. There's just one category of personal data. By nature, health information is extremely sensitive. I think it would be a good practice and a best practice to enforce stricter controls when it comes to safeguarding health data. If possible, de-identify the data, use anonymization, apply stronger access controls, etc.
Is that sitting here today, we are already in March to the compliance start point. What would be the 4-5 key things that as a corporate we need to be doing, right? In terms of data, activity, teams, what are those 4-5 things that we need to be doing? And ideally, what you think might be the time frame in which these need to be completed? Because there's also an issue of
time perspective. That's very subjective because it will depend on the kind of volume of services and work any organization would have. But what are the steps that one can take? And I think I want to really start by saying having visibility of the data that an organization has. Visibility is most important. It will, half your problems are solved the moment you know exactly what you have, where it is stored, what are you using it for, how long have you stored it, and whether you have the permissions in place. So visibility comes with all these 4 questions. Once that visibility is established, it can be either done through a privacy impact assessment, it can be done through flow charts, it can be done through diagrams. As I had earlier said, it is not a work of a single team, it is work of multiple teams, because data, the same data is residing at multiple places. Now I am saying is residing, it's not now a guessing game. Working with a lot of organizations, we've realized that even organizations do realize that it is not at one place. There is no such thing as a master database. Master database gets copied multiple times at multiple places, and people tend to lose track of it. It may be called by different names, and different people tend to get access to it, which goes unmonitored. So that has to be step 1. Once that data visibility, or you have an impact assessment done with mapping it against the data principles that or privacy principles the Act is talking of, it gives again, that is step 2, where you are mapping all the data that you have against the principles. That okay, what is the data that I have? Does it adhere to data minimization? Am I using the data for the purpose that I have collected it for? What is the retention, and do I have consent for it? What are the adequate safety and security things that I have in place? Do I have the proper technology in place? Do I have the proper people in place? Do I have the proper processes in place to ensure that this data is safe? Also to identify, do I really need to protect this data? Because if you're saying, oh, but half of this data is from the public space, do I really even need to worry about that data? So even that is an exercise that, okay, let me cut down my problems to half and let me only worry about half the remaining set. Then one has to think of, then do I have the right consent format in place? Where am I going to store it? How easy it is for my customer, healthcare professional, or whoever concerned, how easy it is for him to access it, and how easy for it is for me to give him that access. Or am I going to get into a big scramble looking for that data if I get asked a question? Like if a healthcare professional asks, tell me the amount of data that you have about me, tell me for how long you are using it, tell me for what are you using it for. Also, let me know with how many organizations have you shared it with. And if that makes you break out in a sweat, it means that a lot of things need to fall in place, right now. And it's always better to be prepared well in advance rather than, wait for that last mile.